Sir, another 5 minutes, sir. We'll start it, sir. Hello? Sir, you are 1 minute, sir.
Yes.
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 Okay, sir.
Fine.
Yes. Fine. Sir, another 2 minutes, sir. We'll wait for another 2 minutes and we'll start.
Okay, okay.
Okay, sir. Good afternoon. Good afternoon, sir. Good afternoon.
Good afternoon.
Yeah. Okay, we'll start the afternoon session with the quote, "Curiosity is a wick, the candle of learning." I take immense pleasure to introduce our session speaker, Mr. Vijay Bhaskar Reddy. He is an advocate enrolled before State Bar Council of Telangana and IPR attorney from Hyderabad. Mr. Vijay has over 15 years of experience in the field of intellectual property rights, and he has completed his BTech Dairy Technology from Osmania University and MSc Food Science and Technology and from Agriculture University. Mr. Vijay has completed his LLB degree from Osmania University. He is also a partner of Roots IP Services LLP, an intellectual property service provider. He is also a facilitator for patents, design, and trademark under the Startup Intellectual Property Protection. Mr. Vijay has very good expertise in conducting patent searches, drafting and filing of patent application, prosecution of patent application, filing and prosecution of industrial designs, trademark, and copyright applications. Thank you, sir, for accepting our invitation, and welcome you, sir, for our Pratusha family. Thank you, sir. You can take over the session, sir.
Thank you, ma'am. So let me share my screen before I proceed. Is my screen visible to you, ma'am?
Yes, sir. It's visible, sir.
And if I move the slides, table of contents.
Yes, sir. It's coming, sir.
Thank you, ma'am, for giving me an opportunity. At the outset, I thank the Pratyusha Engineering of Engineering College and the ACT Atal program for giving me an opportunity to deliver a session on foreign filings under the Paris Convention, International Patent System, that is PCT, and the regional patent systems. So I have prepared slides, and more than that one, I want a very good interaction with the participants. And I have also attended for some time in the first session, and the participants have more questions as far as I know. I'll try to clear all their questions as far as possible. Yeah. Yeah, let us see now foreign filings. So that means, let us see. Yeah. So foreign filing means filing of patent application outside India. Right. So we have to see, okay, so once we are filed in India, we can file the equivalent patent family or the equivalent of the patent application outside the country. So there are three ways to do it. So one is direct filing. The other thing is through the Paris Convention route. And the third route is the PCT, the PCT route by filing of PCT application. Let us see direct filing. So which is almost like an impossible kind of thing. So that means, so if what happens is, like, in the absence of Paris Convention and in the absence of PCT, we have to file only through the direct filing route in order to have the priority date. So priority date means is the first filing date, which gives the protection from the back rate even though we file at a later date. So that I'll explain you when the context comes. So in order to have that priority of the first filing, so in order to not to lose the priority, so we have to file only on the same day. Otherwise, what happens? Let's say if I filed the patent application first in India and in the absence of Paris Convention and PCT, so then it becomes very difficult for the applicant to file in all the countries of interest. So even today, what happens is, if that country is not a member of Paris Convention or PCT, then we have to file it on the same day, almost same time, not to lose the priority. Why? If we file at a later date in a country which is not a Paris Convention or which is not a member to the Patent Cooperation Treaty, so then what happens? Our own patent application becomes a prior art if we file it at a later date. So main thing is, in all these things, the priority date is very, very important. Priority date is that we file at the home country. So the first filing in the home country becomes the priority date. So that is the first filing date, and after which we are entering into through the to other countries through various routes like Paris Convention and PCT. So the first one, direct filing, means we should file on the same day itself. So this is possible only, this we exercise only when that country is not a member of Paris Convention and not a member of PCT, and only
Hello, sir. Hello. அவருக்கு தான் இருக்கு. Hello. Hello, sir.
Yeah. Now got it. So there was a power problem at my place, and
Oh, sir.
sorry for
Okay, sir. Okay, sir.
yeah. So we are in Paris Convention slide. Hope you are able to view it, right?
No, sir. We're not able to view the slides, sir. Just share it
Maybe
again.
that.
Yeah.
Yes.
Yes. Yes, sir.
Thanks, and I'm very extremely sorry for that. So Paris Convention. So it is a convention. So which is mainly intended for the protection of industrial property. Just a minute. So this convention was adopted in the year 1883. So it was much older. So the Paris Convention for the Protection of Industrial Property. So it was signed in France on 20th of March 1883. So this Paris Convention protects patents, trademarks, industrial designs, utility models, service models, trade names, geographical indications, and the repression of unfair competition. So in the year 1883 itself, the world countries have come to a common place in Paris, and they wanted to secure the intellectual property rights of the inventors or the innovators or the creators of intellectual properties. So why? So that means, so in the absence of a common law treaty, so for the protection of intellectual property in other countries, it becomes difficult. Some inventions could be useful in more than one countries, and where they want to commercialize in more than one countries. So in that case, the applicant or the inventor, who himself is the applicant, so it becomes a difficult task for him to protect his invention in more than one countries. So with the intention of that one, so the Paris Convention was signed in Paris on 20th of March 1883. So what is the significance? So this is the first major step taken to help creators ensure that their intellectual property is protected. So before that one, it was very difficult. I'm not sure whether it was possible or not to protect in other countries, but at least I can say it was very difficult to protect invention in more than one countries. So this Paris Convention contains 30 articles, and even it was amended many times. So let us see the main principles of Paris Convention. So what are the main three objectives? So it has three main objectives. One is the national treatment. The second one is the right of priority. And the third one is common rules. So first one, let us see national treatment. So that means all the members are called as a contracting states. So the contracting states must grant the same protection as it grants to its own nationals. So there should not be any discrimination between a national of one country. That means India is a member of Paris Convention. India should not discriminate whether the applicant is from India or is from other member states. So it should not do a favor for its own citizens or its own applicants by altering the law. So for this one, so one main objective of the Paris Convention is national treatments. They should give the same kind of protection. So the law is same. For example, in India, like section 3D, where we cannot get an invention, pharmaceutical inventions as a patent if there is only a slight improvement or there is only a change of form or any other thing under section 3D. So that law applicable to Indian national who are the applicants as well as the foreign nationals as well. So that means whether the invention is filed by the same country citizens or from abroad, there should not be any discrimination. So that is called as a national treatment. Whatever the treatment you are giving to your nationals, the same should be given to the applicants from the contracting states. So this is the first one. And coming to the second one, right of priority. So in the initial, the starting of my session, I told you about the priority. Priority date means the first filing date. The first filing date. And here the right of priority means, so for example, if an applicant has filed uh, a patent application in India on 1/1/2021, let us say, and he has filed his provisional, complete, everything is going on, and he has a 12 months of time to file in other countries as per the Paris Convention route. And what will be the filing date if we enter into, let's say, to United States or to the European Patent Office, which are the members of the Paris Convention? So here we put the priority date as 1/1/2021. So the same date. Why? It is very, very important, because if there is no priority, so what happens is our own patent application becomes a prior art for the examiner, and others could get the protection. Let's say if there is no priority, a person A has filed a patent application in India on 1/1/2021. After 3 or 4 months, let's say on 1/6/2021, in the absence of priority, let's say other person has filed in United States, and on this date, 26th of July 2021, A wants to enter into United States, but almost a similar application is there which was filed on 1/6/2021. Then in the absence of this one, so my own priority, my own application becomes my own Indian application. That means the application filed by A in India becomes a prior art for him, and also the patent application which was filed in United States on 1/6/21 also becomes a prior art. So in order to get a protection for the inventor or the applicant, so this priority date is very, very important. So the first filing date. So if we go through the Paris Convention route, we have 12 months of time to enter into other countries. And what happens? So this 1/1/2021 will be my filing date. So this will become, that means, so the so whenever the examiner is looking at the patent application during the examination procedures, so what he will do? He will conduct a prior art search. So what should be the date? The date should be after 1/1/2021, because the first application was filed in India by A on 1/1/2021, and let's say on this day, 26th of July, he has filed a patent application in the member countries, and all the member countries should respect this one. So that means, so the right of priority should be respected by all the member countries. So by which he gets an application, he gets an advantage. The applicant gets an advantage. How? So because whatever is filed after 1/1/2021, so it doesn't matter to him, because he has filed on 1/1/2021, and it is considered as a priority date. So it doesn't matter how many people have filed after this applicant has filed in that particular country. So this is very, very important priority. So if you lose the priority, then it becomes, that means we have to file it as a new application. And common rules. So the third thing is, because there are different countries from all over the world, and patent law is territorial. That means a patent filed in one country is only enforceable in that particular country, and so the countries should follow according to their own law. So that means a patent, for example, an applicant has filed a patent application in India and United States. So irrespective of the position of the in other countries, so that particular country has to follow its own rules. Why? Because, for example, if it is filed in India and the United States, and the patent application got registered in United States, then we'll inform to the Indian Patent Office also. But in one, what happens is, like, if that application is refused in United States, and the applicant will inform the same to the Indian Patent Office as per the Patent Act 1917, but the Indian Patent Office should not reject on the condition that it is refused in United States. So here the important thing is, a patent cannot be refused, annulled, or terminated in any contracting state on the ground that it has been refused or annulled or has terminated in any other contracting state. So that means, so it's only for information we'll be giving, but just it could not be a ground for rejection. It could not be a ground for rejection. A patent rejected in US, that doesn't mean that your United States Patent Office also should reject it. So they have to examine, they have to conduct a substantive examination as per their procedures and see if there is any deficiency as per the particular country's patents act, then they can object. Otherwise, they are bound to give grant for that particular inventions. So these things mainly will happen, common rules. So mainly in pharmaceuticals, inventions, drugs, and other pharmaceutical compositions. So it will be a little bit difficult, especially life sciences related things. In mechanical engineering, so there will not be a problem with the, so because once you are able to prove that the invention is novel, inventive, and it has industrial applicability, then you will be getting a granted patent. So that should not be a problem, especially in mechanical things. Mainly in life sciences and the software related things, it will be a problem. And as earlier speakers already said that, so software industry is booming up, and India is a big market for the software companies. So even though they get a patent in US, on the ground they cannot enforce, they cannot demand a patent in India or for that particular software. So on the way, so even though if it is refused also, we cannot force it. And even if that patent application got granted, so the invention related to computer related invention, CRI. So even if it is granted in the United States, we can just inform by filing a Form 3 to Indian Patent Office saying that we have got registered. But that cannot be a ground to get a patent in India. So we'll go as per our own rules. So if there is any objection, so they will be giving an objection in the form of first examination report for software related things. So mainly they will be objected under section 3K for pharmaceutical related inventions. We'll be getting the objections mainly in the form of section 3D objections. So according to the Paris Convention route, so these three are main important. One is the national treatment, right of priority, and common rules. So that means there should not be any discrimination between the applicants from the member countries. So among the contracting states for that particular convention, Paris Convention here in this case. Let us see who are all the members of this Paris Convention. So it has 177 contracting states. India is also a member since 7th December 1998. So that means India accepts the patent application under Paris Convention route. So the convention is open to all the states, and they have to deposit the instruments of ratification before the WIPO, Director General of WIPO. WIPO is the administrator for both Paris Convention as well as the Patent Cooperation Treaty, the PCT. So now what will be the advantage of becoming Paris Convention? So that means if a person has already filed in United States, he can also file in India within a 12 months of time. So that time period is very, very important, that 12 months. So what happens if I come to India in 13 months? So the system will not allow to register or to apply for as a patent through that priority. So that means if you do not come within the 12 months, so the applicant loses priority. So if you look at, so this is the page I have taken from the e-filing portal. So here there will be various types of application, so which are entering into India and which an applicant wants to file before the Indian Patent Office. So here we need to consider it as a conventional patent application, and yes, so where we have to enter the earliest priority date. So that means if it is filed in other countries, let's say US, UK, or Australia, so we have to enter. So if that earliest priority date, so that means it can be a case like this on 1/1/2021, the applicant might have filed in US. Maybe after 2 months, maybe he might have filed in before Australian Patent Office, and maybe after maybe in the 5th month, he might have filed in maybe Canadian Patent Office. So which are all the members of the Paris Convention. So here the Indian Patent Office is mainly interested in the earliest priority date. So the earliest priority date is on the date the first application was filed, that is in this example. So it is 1/1/2021, not the later filings, though they are between the 12 months. So they can be, so that means the applicant has been filing in different countries on different dates within that 12-month period. But what is important is the first filing date, earliest priority date, that should be entered. So that should be within the 12 months period. So if that is satisfied, so then we can apply before the Indian Patent Office for the grant. So that is PC, that is about the Paris Convention. So it has got yes advantages, yes definitely, because it is giving, there is no discrimination between the applicants, yeah? And the right of priority is that means it is considering, and there is same common rules are the same for all the people. It has got so many advantages as well. But there are certain disadvantages or things like that means, so the period is only 12 months. Yeah. And whenever you are entering into other countries, let's say non-English countries, so the applicant has to submit the translation copy of that one. So a verified translation has to be submitted. Let's say the applicant has filed in India and he also wants to file in Korea, Japan, China, maybe Germany, and other countries. So here what happens is the applicant within this 12 months period of time, he has to file in other countries, as he has to file apart from the paying the fee, the formalities, and he has to submit the translation copies. So in some countries, it is very mandatory that we have to file at the time of complete specification, or maybe they may give certain limited period of time. So which will be difficult, because if you are a small applicant, maybe could be an individual or a small company, then it becomes extremely difficult for this applicant to meet all the requirements. Before that means especially the translation and to find the attorneys. So that means we cannot file from here for other foreign countries. Let's say if you want to file in China or Japan or any other country, so then we need to contact those attorneys as well. So even though he is hiring an attorney in India, sometimes it becomes difficult for these small applicant, because he cannot afford huge costs that are charged by the foreign attorneys. Then and this 12 months period is a very short time for him to take decisions. One thing is he'll be working on the inventions to make it final, and at the same time he has to comply all the formalities and the technical objections as required by the different patent officers. So then what happens is then the member countries, they have come up with another treaty called as a Patent Cooperation Treaty, which is administered by WIPO. So WIPO has come up with another alternative apart, in addition to the Paris Convention route, which is called as a Patent Cooperation Treaty. What it is an agreement for international cooperation in the field of patents. So in the field of patents, whereas Paris Convention protects in all the intellectual properties, but whereas this PCT, Patent Cooperation Treaty, is exclusively for patents, not for other kinds of not for other kinds of intellectual property rights. So it is an agreement for international cooperation. So many times what happens in general is we hear that yes, we have an international patent, right, or a world patent, right? So there is nothing like that world patent or the international patent. Patents are territorial. So either they have to be given by the particular country or the regional patents, regional patent system. So not for if you want to say that I need a world patent, so almost it is impossible. So at least you need to get in all the countries, then only you can say that it is registered in all the countries of PCT. Most of the times, what happens, how we tell to public is that we have got. So looking at that WO publication, WO 2021, some numbers will be there. So that it is a PCT publication. We have to call it as a PCT publication, not the grant. So we should not say that we have got a world patent published or registered or whatever it is. So WO indicates world, but it is not a world. So that is for the country code for the PCT. So every country has a country code like PCT. So if the application is published by the WIPO, then it will be like a WO and the number. For Indian, it will be IN something. IN is the country code. For US, it is a US, like that. For European Patent Office, it will be EP. So the country code. And there is nothing like a world patent. So try to understand. Yeah. And if someone says that there is nothing like a world patent. And there is only what we call is international application. By through the PCT, we can file an international application, international patent application. So this PCT plays a very, very vital role in protecting the inventions outside the country. So it was entered into force in 1978. So it is operational since June 1st, 1978. Initially, only 18 contracting states were there. So because in 1978, so many of the countries did not have proper intellectual property law at their national level. So even though we had, that means the act we had earlier, the act that was is like we have Indian Patents Act 1970. So India was also initially not a member of the PCT. Later it became. So at that point of time, only 18 countries, mostly the developed countries, were part of it. And as we are member of WTO, so we had to, as per that agreement, we need to upgrade our patent law and we had to update our patent laws as well. And now, as of now, we have around 153 plus or minus 1 or 2. So 153 contracting states. So why PCT? So already why we have to go for PCT already when we have direct filing method and the direct convention route. Let us see in the this slide and the following slides the importance of PCT. So the PCT makes it possible to seek patent protection for invention simultaneously in a large number of countries by filing a single international patent application instead of filing several national or regional patent applications. So by filing a single application, so we can get it granted. So I say that this application will be going out to different patent offices across the world who are the members, and then you need to pay the fee in the particular countries, and then you need to obey those the forms and other formalities, and then it will go to the examination. But initially what happens is like, so you should not worry about that one. So because once you are going through the PCT route, so only thing we have to make is within this 12 months of time, you need to file a PCT application. So by filing PCT application, the applicant gets about 30 or 31 months time to enter into the national phase. So that means it's a very good time. So from 12 months, so you can defer decision till 30 or 31 months. So that means we have enough time. The applicant has enough time. Yeah? And the granting of patents remains under the control of the national or the regional patent offices in what is called the national phase. So by filing in the PCT, so we have two phases. One is the international phase and the other thing is national phase. So once the application completes the international phase, it comes under national phase. So the two phases, and the patents will be granted under the national phase. So once the international phase is over, the applicant has to file the correspondingly all the fee and other things before the respective patent offices, and then the national phase entry starts. So there is nothing like international patent. It's only international patent application. So this is a map. So where PCT applications are accepted. So almost all the major countries accept the PCT contracting states except a few. Now, let us see what are the various stages in the PCT and how it differs from the Paris Convention route. So this chart, so we have about, so if you file the patent application today, so that becomes the day 0, and we have 30 months of time. And in between, so we have various stages. So which I'll explain in the following slides. So main internet. So in the first thing is, so you need to file this PCT application within 12 months. So then what happened? So then we have other stages which I'll show you in the next slide. So there are mainly 5 stages in the PCT. So filing of PCT application, international search report and written opinion, file demand or international preliminary examination, and international preliminary report on patentability. Apart from that, we have 2 optional steps. So request for supplementary international search and supplementary international search report. So this here it is a comparison. So between the Paris Convention route as well as the PCT route. So in the Paris Convention route, everything ends in the 12 months. The applicant gets up to 30 or 31 months. So he can differ. So he can defer his decision to he can make a choice and then he can enter, which was difficult for him in the Paris Convention route. Let us see the stages now. So the first thing is, so as I said, it is a 5, but if you include that national base, it becomes a 6 steps involved in the PCT procedure. First thing is filing of PCT application. Then there is international search. Then we have international publication, and then we have supplementary international search, which is an optional step, and international preliminary examination, which is also an optional, and then we have the national phase entry. Let us have a look at the filing. Filing an international application with a national or regional patent or the WIPO, complying with the PCT formality requirements in any language, and you can pay one set of fee. So that means once we file patent application in India, so the applicant can file before the Indian Patent Office or directly with the WIPO through the there are different filing mechanisms like as the electronic filing is acceptable by WIPO through the PCT safe or the ePCT. So in the out of these 2 ways, so the applicant can choose one and he can file in other countries. So only thing is only one set of documents. So that means, so there is a prescribed format of filing these patent applications. So that means, so if you prepare according to the specification, then you can file it. So the WIPO also maintains IP portal. So the agents, the attorneys, or the individuals applicants, they can also register their user name, and they can go through that registration process. Once you complete it, then you have a username and a password, because through using which you can log into the WIPO account and you can file the PCT application. So this is an example of how it looks like after filing. So this was filed using PCT safe. So the other mechanism I mentioned is ePCT. So you have to provide all the details. So you can keep it handy, what all the information it is required. So once you prepare the application, once you file it, and you have to pay the fee. So that fee is around $1,400 per companies, and there is a 90% reduction for the individuals. So that means if you are entering the PCT phase as a company or as a legal entity, so then you have to pay around $1,400 as the official fee, and apart from that one, so there will be attorney fee as well. And there is a 90% up to 90% reduction in the fee for individuals in the sense natural persons like Vijay Bhaskar, maybe Srinivas and other people. So without any legal entity. So here, depending upon the type of applicant, so you have to enter at the time of filing, and then it will calculate the fee accordingly. In this particular application, so this is taken from the WIPO portal itself. I have filed this application. Here, if you look at the transmittal fee is $102 US, search fee is $137 US, and the international filing fee is 1,352. And we have selected the International Search Authority as the Indian Patent Office. Total, it comes around 1,352, but there is also a reduction if you go through the electronic filing, and the total international things become somewhere around 1,149, and you add the search fee and the transmittal fee, total it comes around 1,388, so around 1,400 US. So this is the fee, and I have also provided the site where you can look for the different fees for different applicants from different nationalities. So here the nationality is very important. So the fee waiver is applicable for mainly depending upon the developing country. If you are like India, it gets some fee reduction even for as an entity as well. So the fee differs from country to country. And then what happens is, like, once you file the PCT application, you'll get that PCT application number, like you have here. It's not there, so it will be given separately PCT number. So once the application or the formalities, the fee is paid, and the application is completed successfully, then what happens is that the WIPO will conduct WIPO will conduct or the International Search Authority. So we have that will conduct the prior art. So in order to identify the relevant documents, so whether it is a good decision to file in other countries, or whether it is necessary to amend the application looking at the results provided by the International Search Authority, or is it good to file as it is, because looking at the prior art. So what happens in the prior art? So they will give you some certain report, international search report it is called as. So where they'll try to give some objections, examination or citations, what we call in the X or Y or the A. So X means claimed invention cannot be considered as novel or cannot be considered to involve an inventive step when the document is taken alone. Y means claimed invention cannot be considered to involve an inventive step when the document is combined with one or more such documents. And A is a technological background, no objection regarding novelty or inventive steps. So that means if there are more number of X and Y, so that means there is a problem with the application. So there is a problem with the claims. So the claims may not be granted if you file as such. So you have an option also to amend within the scope. But if there are more number as yes, so that means technological background, so which will not harm you. So let's say I'm trying to file a patent application relating to something like related to touch screen in a different way. Maybe instead of touching itself, maybe from a distance itself, I'm able to open my mobile phone. Let's say, like for the touch screen, you have to touch it, but if that sensor recognizes, even though it is from a distance, I put the patterns or I put the numbers on it, and if he's able to recollect it, so that is a great thing, right? So that means here in this case, no one might have filed this kind of patent application altogether without like a proximity sensors kind of thing, which operates based upon some kind of proximity sensor. No need to touch the phone itself, or maybe like this. So that means what happens? So till now, no one has filed that one. In that case, there will not be X, there will not be Y. Only thing is technological background. Maybe the nearest prior art would be like a touch related patents, or maybe the patents which work on my voice, or some kind of other technologies. But so there is nothing, because this is the first patent of this type. So in that case, we will not have X and Y, but we have only A. So that means A means, if you have A means that we can go ahead easily without any amendments to the patent application and without any doubt. So the more number of X and Ys we have, so that means there are more number of similar inventions, similar patents already filed, whether they may be granted or in the prosecution sale or already abandoned. So it doesn't matter. So that is going to affect you. So that means while conducting the search, they look for worldwide literature. It could be a patent, it could be a research publication, journal article, maybe conference proceeding. So somewhere it is mentioned means yes, they will cite it as either X or Y or A. So we have to take care that thing is that if uh, uh, if we are going to see, that means we have to see the worldwide novelty. So that means it should not be published anywhere in the world in order to get granted. Yeah. And written opinion also they say yes. So whether there is novel, inventive, industrial applicability. So in whatever the session you are, so these three terms play an important thing. So when you are dealing with the patents, so novelty, inventive step, and the industrial applicability, so they play a vital role. The entire application revolves around these three parameters, whether it is novel, whether it is inventive, whether it has got industrial applicability or not. So looking at these things, they will say the International Search Authority will give a non-binding. So it is the report given by the International Search Authority is non-binding. So that means it gives a kind of a signal or indication, but it doesn't mean that one. So that means if there is any search report favorable, and maybe let's say that the applicant is from US and US Patent Office has conducted the international search and it has given a favorable result, but he cannot enforce that one before the Indian party saying that, hey, you see that US patent has already given me as a positive search report, you please give me a patent based on that one. No, because patents are territorial. Every country has its own rules. And why? This gives a signal. So if there is any specific objection in the section 3 or section 4, which deals with the inventions not patentable, then the Indian Patent Office may cite those objections. International publication, like how our national applications are published after 18 months. So the WIPO also publishes under the, you can view it under PCT scope. So that means all the patent applications which have completed 18 months, so the WIPO will publish once the application completes 18-month period. Till that time, it will be kept as a secret. And we have other two optional steps, the supplementary searches, like a second international search authority identifies at your request published documents which may not have found in the first ISA. So if you have any hesitation or if you need a second opinion from that one, you can also request for supplementary international search. So then they may go very deeply into that one. Then I'll try to find it out. Maybe the first step, maybe it could have got missed because of the language translation and other things. So they will try to take one more round of search, and they'll try to give you the nearest prior search results. Especially we have to see that it becomes like it becomes a problem in getting the translation one. Like let's say that foreign prior art is in let's say Korean, Japanese, or maybe Chinese one. So the international search authority sometimes they cannot get same thing, which at a later stage the Chinese patent office can get it because they can search in Chinese language and then they can retrieve very good results. Because once you understand the concept, the Chinese they will conduct in English language, and they may also conduct a search in their own language, and they can retrieve better documents one what this ISA has founded. And this supplementary international search at least uh, uh, avoid certain prior arts which will be found at a later stage. So that means if you think that you need a second opinion, you can also go for a second international search authority. And international preliminary examination. So one of the at your requests, so they will do additional patentability analysis. So why this is required is because there is a cost involved. So once you want to enter into different countries, let's say in India it's very cheap, like So it's economic is very easy to pay the official fees. Like 1,600 is the official filing fee if you file through the e-filing mode, and 4,000 is the examination fee. And if you do not want early publication, no need to pay that additional 2,500. So that means 4,000 plus 1,600, and I can wait for 18 months. So then no other fee is required. But if you have filed to the PCT, so it costs you around. So if you are a company, it costs around 1,400. Otherwise, somewhere around 150 USD. So 150 USD for filing, and then you have to enter into the national phase. So which will be, if you enter into, let's say, US, so the government fee itself will be around some 470 USD. If you enter into Europe, it will be around more than some European, like more than 3,000 euros. Like if you enter into Australian, so like every country, so the average ranges will be in the range of some 300 to 500 US dollars in each country. So which will become expensive. So you cannot just like that enter. We have to see that if this patent is an intellectual property, it is considered as an asset. So the patent is an asset. So what you have to do, you have to commercialize. If you want to commercialize, then only it is suggested to file in a number of countries. Otherwise, you can restrict yourself with 1 or 2 countries. And if you are very sure that you do not want to go with any other country except India and the United States, then no need of PCT. Within 12 months, you can file in United States through the PCT route. Sorry, through the convention route. No need of PCT. So if you are very sure that I want to file in only in 1 or 2 countries, then it is better to go with the conventional route. And if you are not sure and you do not know about how it will be, like the business prospects, because there is a cost involved and you need to commercialize it. So you do not know in the beginning or within the 12 months, then it is suggested to file a PCT application, and then you can do your research in that particular country whether to go ahead or not to go ahead. And once this international phase ends, then the applicant has to file in the national phase. So what happens if I do not enter into the national phase? What happens if I am not careful about this one, thinking that yes, already I have filed a PCT application, then nothing to do from my side, then it is a mistake on the part of the applicant. It will be only like international publication, and then you cannot file in other countries because you did not enter into that particular country within the 30 or 31 months period. You can enter maybe looking at the international search report and other things. Maybe from 19th month or 20th month, you can start preparing decision. Okay, whether I have to go to United States or United Kingdom or Australia. So where all I have to file it. So by the end of 30 months, so you have to file the national phase application. Similarly, if the applicant is from other countries, let's say United States or from Europe, he has to file an application before the Indian Patent Office within that specified period of 31 months for India. So this is a page that I have taken from the e-filing portal of Indian Patent Office. So here we need to provide the details of patent application, and Indian Patent Office can retrieve those results from the WIPO website. So we need to enter that publication, so that the system will accept only if that application is filed before 30 or 31 months. So that means it is suggested to enter into the national phase at the earliest possible time. So once you have made a decision, so you need to start entering the national phase, and maybe you can do it in a phase wise. You have this PCT application first. Maybe if the applicant is from India, and if he sees that United States could be where I can commercialize my invention, then you can file maybe in the 20 or 21st month, or maybe 28th, 29th month, but not later than 31 months. So it is very, very important to follow the timelines, especially when you are dealing with patents. Let us see the advantages of the PCT. What are the advantages by filing a PCT application? Brings the world within reach. So that means by sitting here in India, we can file a PCT application. Postpone the major costs associated. Sorry. So one thing is the cost. Let's say if you are an Indian applicant and if you want to file in other countries, so within 12 months through the convention route of Paris Convention route, so that means you need to spend a lot of money within 12 months. And maybe at a later point of time, you cannot get any refund, even though you are not entering into that particular country. So you have spent a lot of amount and you are not sure whether your invention will be commercialized in that particular country or not. So therefore, so at least you can delay that cost by filing a PCT application. So provides a strong basis for patenting decisions, because you know that one, whether it is how it is doing in your home country or in some countries, and you can estimate whether this invention can be commercialized in that particular country or not. And one other advantage of filing a PCT is harmonizes formal requirements, because in each and every country, so they have a little bit of formal requirements like, okay, various forms have to be filed and the application has to be filed. Let's say in India, the first page has to be the form 2 page, form 2 where we have the, and we need to have the preamble. So that means, so in order to minimize the objections, formal objections, so it is suggested to file as a PCT route, and protects applicant from certain inadvertent errors. So that means there should be some requirements from each and every country. So he may not, which he may not be aware at that particular point of time. So then by filing PCT, then he has time to study about the patent system in that particular country. And one other very, very important thing is evolves to meet stakeholder needs. So that means you have filed in PCT, you have filed a PCT application, and once the PCT application is published, the world comes to know during the various by searching, or maybe because the patent application is published by WIPO. So many countries have the access to the PCT scope, the patent database, and if that particular university applicant or maybe is needed by multinational companies, they may approach you and they may say that yes, we are interested in commercializing this patent and we are ready to bear the expense, patent related expenses, and we may give certain kind of royalty, or maybe they may want the outright sale. Maybe you might have already heard in other sessions that a patent, like a physical property, that means it can be sold. It can be sold, it can be mortgaged, and it can be licensed like any other physical property. So there is not much difference. Only thing is you need to pay the renewal fee properly in order to get your rights enforced. That's the only thing. And other advantage by filing PCT is allows to apply securely and easily online and to save money. So we can file it online. So some countries earlier, so like you need to file it physically, so before that patent office. But in the PCT, you can file it online, and it's more secure. So no need to worry about various payment related stuff or anything. You can pay in US dollars, and that should be fine. And save money, yes, because you do not know where to file, and it saves money by not filing in different countries and not to take a hasty decision. So this is about the PCT. Then apart from that one, we have regional patent offices as well. Like in the world, majority of them are like major regional patent systems, or the European Patent Office system, the Eurasian Patent Organization, the African Intellectual Property Organization, and the African Regional Industrial Property Organization, and the GCC Patent Office. So why you need a regional patent offices once you have the individual, because I am already telling that the patents are territorial, right? The patents are territorial, and the patent given by one country cannot be enforced in other countries. Then again, still why you need a regional patent offices once you have your own patent office, especially in Europe. So they have through the European patent office. So it was formed through an intergovernmental organization, through the The basis is a European Patent Convention, so which was signed in Munich in 1973. So the members of the European Patent Convention, mainly the European countries, they have come together and they have concluded this that we need a common patent office, European Patent Office. In spite they have their own individual national patent offices, but they have come together that okay, so let us form as a group, and the patent given by this regional patent office is enforceable in all the member countries. In all the member countries, provided there are certain formal requirements the applicant has to meet, and he has to pay the fee before the national patent office for the enforcement. So in order to get some kind of a simplified thing, so they have come together and set up regional patent offices. The best one is the European Patent Office. So the European Patent Convention, so it establishes two things. One is the European Patent Office and the Administrative Council. So the Administrative Council of supervises the office activities. So that means, so whenever you are entering into regional patent offices, so one thing we have to note is that patentable subject matter should be almost same, because let's say in Europe, so there are about some around 30 or more than 30 countries as the member countries for this European Patent Office. And if there is a significant difference in terms of patent law in each country, then it will be difficult for the regional patent office whether to give it or not. Because when they have the common patent law, then only the European Patent Office can examine and say that, okay, under the European laws, it doesn't say that it is under the German laws or French laws or Dutch laws. So under the European patent laws, it can be granted as a patent. And then the applicant has to pay the fee before the respective national patent officers for the enforcement. And if there is a significant difference, and this European Patent Office has granted, and the National Patent Office says, no, this was not checked properly, this particular section or rule of the Patents Act, and then we cannot be registered, or you need to fulfill, then it becomes a chaos. So that's the reason why. So if the patent law is harmonious between the countries, then it becomes easy to set up regional patent offices. And one successful is the European Patent Office, which takes a number of initiatives and between the member countries, and also it provides very good suggestions for WIPO and other countries of the world. It is very, very effective, European Patent Office. And the other regional patent office is Eurasian Patent Organization. So mainly for the erstwhile Russia, erstwhile USSR. So there are about 9 members like Turkmenistan, Republic of Belarus, or Republic of Tajikistan, Russia. So if you look at these countries, so these countries were earlier part of USSR, which they had one common law relating to patents, and the member states also have the same law, which is almost same in all the countries. And this EAPO, Eurasian Patent Organization, it grants patent for this region. Similarly, African Intellectual Property Rights Organization, so OAPI. So there are certain countries, and the member states of this OAPI are also members of the PCT. So the member states of the OAPI are also members of the Paris Convention for this one. So most of the times, these European Patent Office and this regional patent office. So the members as such, the regional patent office is a member of the either the PCT or the Paris Convention road, and even the individual members will also be the members of the individual members of the Paris Convention or the members of the WIPO. Similarly, ARIPO, so this is also there. So the African Regional Intellectual Property Organization is an intergovernmental organization that facilitates cooperation among the member states. So it was formed based on the Lusaka Agreement on 9th December 1976. So the ARIPO itself can be designated under the PCTE. It is also a member of the Paris Convention for the protection of industrial property. And the other thing is the Gulf Cooperation Council. So where we have members like Middle East countries, Bahrain, Kuwait, Oman, Qatar, Saudi Arabia, and the United Arab Emirates. So they have a common patent system, and its office is in Riyadh, Saudi Arabia. It is one of the newest one. So the new law came into effect on October 3rd, 1998. According to GCC patent regulations, once the GCC patent office grants a patent, all the GCC states recognize that and offers its owner protection. So that means, so you can take it as a group as well. So these are about the regional patent systems. Yeah. And before I forget, I want to tell you that, okay, foreign filing license. So because as already we are dealing with foreign filings, so here in India, so there is one section 39, and under which what we have to do is, when an inventor or an applicant who is a resident in India wants to file a patent application outside India first, it is necessary to obtain foreign filing license from the Indian Patent Office. I'm not sure whether it is covered in other classes or not, but I want to give you a brief introduction that one. So what does it say is, being a resident in India, it may not be a citizen as well. Being a resident, if you are there in India for about 6 months, you become a resident. So if you are there about some 180 or 182 days, so you become a resident. So once you become a resident, and whether you are an inventor or an applicant for that invention, what we have to do? First, we have to file in India. And if you do not want to file in India first, then you need to get foreign filing license. Yeah, from the Indian Patent Office by filing Form 25. And relevant section is section 39. So you have, let's say you want to, because you say that, okay, my invention, I do not want, because I do not like Indian Patents Act, or I'm not at all interested in India because I do not see any potential benefits of commercialization in India. I want to file directly a PCT application without filing in India. Then in that case, you need to file, you need to get a foreign filing license. Or what you can also do is, you can file in India, wait for 6 weeks of time. So basically, you can file a provisional patent application in India. You can get the patent application number and the filing date, and you wait for 6 weeks, and then you can file it as a PCT or any other as a conventional patent application through the Paris Convention route. The only thing I want to say is, first, you have to file an application in India because you are a resident of India, and as you are a citizen of India. So you have to file first. If you do not want that one, so you need to inform the patent office saying that I do not want to file a patent application in India. I want to file outside, and you have to give at least the abstract of that invention. Then only the Indian Patent Office can give you the foreign filing license. So within 2 to 3 weeks. So this is all about my session.
Yeah.
Over now.
Okay, sir. Thank you, sir. Yeah, thank you, sir. Thank you, sir. Participants, you can unmute your mic and you can go with the questions if you have any doubts. Hello.
Yes, please.
Participants, if you have, yeah, you can unmute yourself and you can go with the questions.
So one thing we have to make in mind is, many times most of your researchers are working in colleges. So we have to see, is it worth to file Australian innovation patent? So this Australian patent innovation patent is only, it accepts till next month. So till August, I think August 31st or something is the last date to file Australian innovation patent, after which this Australian government is going to scrap this Australian innovation patents. I know, like many of researchers, so they want a patent application from outside because they will be having more points, or maybe to say that I have a patent outside India as well. So for that one, most of them, what they are doing is, so they are filing a patent application as a innovation or the innovation patent or the innovation utility, not the utility model patent, but usually as a utility model. So you can file in Australia, and there will not be any substantive examination, only formal examination will be there, and you will be getting a certificate.
Yes.
And one other participant has asked, for filing a patent, attorney is a must, and how they charge for individual patent drafting. So for filing a patent application, you can file it on your own, because if you attend these kind of sessions, and maybe for first few cases, you can take the help of attorney, but later you can do it on your own. And being the science graduates, most of them, they can appear for the Indian patent agent exam, so where you'll be examined on the various aspects of the Indian patent law, and once you clear it, you can also become an Indian patent agent, and you can file the patent application for yourself and also for your institutions, or you can practice as a patent agent itself. Yes. And regarding the charges, it depends upon the uh, it depends upon the complexity of the invention. So if the invention is more complex, and if more figures have to be made it, or more work has to be done, then the charges will be more. And generally the law firm, big law firms are there who are filing most of the patent applications. So they charge around some 1 lakh to 2.5 lakhs as their professional fee. 1 lakh to 2.5 lakhs as a professional fee. And yeah, so if you go to, maybe if you can do enough amount of work, let's say now you know, okay, what your invention is, you have to prepare the invention in detail, and then you can go to any attorney saying that, sir, I've done most of the work. Only thing is you have to do a vetting part, and then you can negotiate for a better price. And yes, one other participant is saying that Australian innovation patent do not have a rigorous exam policy. Is it going to affect the credibility of the work? So here in Australia, we have to remember innovation patent is one, and the utility patent. So in a utility patent, the same thing, the novelty, inventiveness, and the industrial applicability, they'll be examined, and you'll be getting the examination report. So Australian utility patent, or the normal patent, what we call. So it has it will be there, but only for the innovation patent. So the rigorous exam policy is not there, and is mainly thing is what I see is most of the academicians only are filing or opting for this one. So because here their purpose is different. The purpose of a patent is to get commercialized, and you have to get to reap the benefit, and you have to reap the benefits. In this case, none of the Australian innovation patents will be commercialized. No one is going to launch a product or a service or anything there. So it's only for the namesake most of the time, because there is a pressure on them to have foreign patents on their name, and that's the reason why most of them are filing utility patents in Australia. And what the Australian government felt that, so because nowadays there's no need to have two patents, and they are going to stop this innovation patents very soon, in within 1 or 2 months. I do not know the exact date. I think it is from August 31st. Only 1 more month you have if you want to get innovation patent from Australia. After that, maybe from September onwards, it will not accept. Let us see other messages. Sir, please provide information for Form 25. After filing Form 25, it is expected patentee to get permission in 21 days. If not received, so you can just send a gentle reminder to them if it is not there, or you can talk to that particular patent office. Let's say most of them are, I think, from South India. If you are there, if the applicant is from South India, you can talk to Chennai Patent Office, and you can know the status why there is a delay. Maybe sometimes what happens is, if there are lot many numbers who have filed Form 25, then it may take more than 3 weeks, because every day, because there is a limited resources are there to examine into this one. So he does his work. and let's say in one day only there are some 100 to 200 patents or 100 to 200 form 25s are filed, then it becomes difficult for that limited resources, maybe one, two, or three. Then in that case, there will be a delay. But if you want to get an update, you can write an email or you can contact that section by calling to the patent office. And yeah, so and the general thing is it is not so easy to get a line. So you have to have some little bit of patience to talk to patent office because it will be IVRS and you need to get connected to that particular section. And please provide information for form 25. So I did not get Sunil Gupta what exactly you mean. What
Sunil
information?
Gupta, Sunil Gupta, sir, you can unmute your mic and you can go with the thing, sir. Hello.
Yes, sir. Yes.
Yeah. Gupta, sir. Dr. Sunil Gupta.
Yeah, maybe I can. So this is a wonderful book you can maintain in. Yeah, please allow Sunil Gupta sir to speak on that one. So this is a wonderful book, which is from a universal publishers. So the latest
Hello,
version you
sir.
can. Yes, sir. Sunil Gupta sir.
Sir, I filed the form
எல்லாம் mute
25.
ஆயிருக்குதா? நம்ம
Yes.
unmute
Hello,
பண்ணாதான்
sir.
ஆகுது.
On 1st
Yeah,
of
I'm
July.
able to hear you.
And
1st of July.
till
Yes,
date,
sir.
I didn't received any permission from their side. I inquired about it, so they are giving me some abrupt reason, just like the
Like?
things that you didn't mention email address in your application. But there is no such provision when we are filing the form. We filled all information, even our phone number and all sort of things. And they are telling that your email is not there. That's why that's why we are not unable to send you the permission. Another thing is that, sir, another thing when we ask them that we digitally signed the form, again they are asking us to that you have to sign the form physically, scan it, and then once again send it.
Yes,
So
sir. Yes,
how
sir.
we
Yes,
can
sir.
send those form to them? And they are once again forcing us that you have not filled the form through agent. That's why you are finding such difficulties.
The agent
Is it
is an
mandatory
optional
that we
thing.
should have to fill the form through attorney agent?
No. No, sir.
I am
This is
from
not a
Maharashtra. My region
mandatory
is
thing.
Mumbai, and we are
Mumbai,
facing
yes,
a
sir.
lot of trouble from patent office.
Sir, once you have now you know you can get a form 25, and if there is any lacuna, you can send it again, like saying that mentioning. So you can send it. Please update my email ID as per this record, or you can also send one more scanned copy through to the uh, to the Indian Patent Office at Mumbai.
Sir, with the help of form number 30, I send once
Yes.
again to them, but they are
Yes.
not responding,
Yes.
sir.
So what I believe is that is one thing, and maybe there's no, I do not see any other reason, only because already that 3 weeks is already over, maybe, and almost
Over,
4 weeks.
sir.
Maybe
And
wait
sir,
for,
our
yeah.
phone number is there and all sort of things we put up whatever
They will
they
not
ask.
call you, sir. In general, they will not call you. It is applicant. We have to follow up, sir. So we have to follow
Even
up.
we
My
registered
only,
our number for SMS related things there. When we sign
yes, sir.
digitally, at that time they ask us that provide your mobile number for getting the updations related to your patent.
Yes, yes, that is a mandatory thing. So once you are filing digitally, so we have to get a number. But only thing is, very rarely we get a call from the patent office.
I'm not expecting
And
any call, but the simple SMS they are not even doing SMS or not saying thing.
this,
Sending
yeah, sir. Even I faced earlier a problem with the Mumbai patent office, mainly for Form 25. But I followed it up, and I called the concerned person, and yeah, then they gave an answer saying that it will be done next week. Then I waited because there are a lot many applications. That's what they were
Sir,
telling.
form number 30 is okay. Means for doing some corrections or updating our
Yes,
email
yes,
address.
yes, yes, yes,
So
yes.
through form number 30, I informed them 2 days back, but still they means I'm waiting for
Maybe wait for
response from them.
3 or 4 days more, sir.
Yes, sir.
Today is Monday, right? You can wait for 2 or 3 days and try to call to that foreign filing license department one. You can talk to the concerned person saying that you have already filed this one. And if it is not there, you put up all the files and you can address to Mumbai Patent Office itself.
Okay.
Because email communication will be more. So because there could be some kind of lacuna saying that you did not give your email ID in the application, but now you are giving. Now you are giving
Yes.
all the details, and you
Yes,
are
sir.
also giving the details of the invention, right?
Yes, sir.
Yeah.
Means they are
Then
asking me that whatever the electronically filled 20 number form number 25 is there, download them, take the printout, do the physical signature
yes,
of all applicants, and then once again resubmit it.
yes, sir.
This is
That we have
also they are
to do.
asking us.
Yes, sir, because they need the scanned copy of that one, sir. Because what happens is like, so if you sign it digitally, it says digitally signing, but for their record purpose, because they'll be downloading the PDFs. So at that time, signature will not be there.
Okay.
So that's the reason why they ask you take the hard copy, sign it, and you send the scanned copy with along the sign. And you can do that one. You can send
Okay.
it. And sometimes earlier, what we used to do is we used to send all the documents, signed documents to the patent office. And now also there is a rule that if they ask for hard copies, we need to submit in 2 weeks.
2 weeks. Okay. Okay. Thank
Yeah.
you very much,
So
sir,
you can
for your
provide also.
valuable
So
information and
we do
moral
want to
boosting
find the
answer.
invention, and in order to avoid these kind of things, I have one simple solution is because anyway for foreign filing license also you have to pay the fee, right?
Yes, sir.
Yeah, you have to pay the fee. So better is
Yes,
you
sir.
at least you file a provisional with the same
Hmm.
abstract whatever you have. You can file in
Hmm.
India. You can get the
Hmm.
filing acknowledgement. Wait for 6 weeks
Hmm.
instead of 3 or 4 weeks. Already you are waiting. Wait for two
Yes,
more
sir.
weeks, six
Yes, sir.
weeks,
Hmm.
and you can file outside. No need to get any permission.
Okay.
By
Yes,
that
that
way,
is
what happens
also.
is, you can
Yes, sir.
also have right now you are not having any patent application in India because you are
Hmm.
taking a foreign filing license. But
Huh.
by following the way I told, you can file a provisional and you have 12 months of time to come to file the complete specification, and your
Hmm.
application is in the queue in India as well. If the time
Yes, sir.
arises, you can
Hmm.
request for examination and you can get the patent application granted in India as well. And if you do not like, forget it.
Okay. Yes, that is
So
also.
this I suggested because nothing to wait, because as per the law you have to wait for 6 weeks. Let's wait for
Yes,
six
sir.
weeks.
Hmm.
Anyway, it will take some time for you to prepare the application, right? In
Hmm.
order to think where to file and other things. So my
Yes, sir.
suggestion is
Hmm.
do first filing in India, wait for 6 weeks.
Okay.
From next time onwards, this time you can
Yes, yes,
try.
sir. Thank you very much, sir. I will do definitely these things. Thank you very
Yeah,
much, sir.
yeah. Thank you, sir.
Anyone is there? Any other questions?
So here we have to
Sir,
understand. Yeah. Tell me.
sir, now I have a doubt. So what is the difference between process innovation and product innovation? Both of the thing can be patented, correct, sir?
Yes, yes, yes. So here earlier, what happened was like when this before this Patents Act Amendment 2005, so there were only process patents for the pharmaceutical related things. So that means once you are, let's say you are making a syrup or composition or anything. So before to 2005, so where there were only process patents and not product patents in the field of pharmaceutical and food compositions. So you need to file only a process for making that syrup or a process for making that drug, not the composition or the not the new molecules. So they were not patentable at that particular point of before up to 2005 amendment.
Okay.
Now we have both process and patent. Both can be patentable.
Okay, sir. Okay, thank you, sir.
Yeah.
Yeah,
So,
thank you, sir.
so
Anyone,
which is
any,
more important that you have to see. So if you
okay.
go with the process patent, let's say a
So,
process for a
only ideas can be, even can be patented, correct, sir? Novel ideas.
Yes, you can file it as a provisional, but in order to, because that embodiment should be there, that working of
Okay.
invention, because
Okay.
someone, yeah. So whenever you are dealing with the complete specification, so that it should have the claims part, the
Yes, sir.
enablement.
But in
So-
Australian patent, only they are filing with the ideas, correct, sir?
Because it's only to be going to be there for more 1 month, ma'am. After that, it will be
Okay.
scrapped.
Yes. Yes, sir. Because here we'll be going with claims, everything. We have to take it, everything.
Even in Australia, also there are two routes. One easy route
Okay.
is to get through the innovation patent. If you want to get a utility patent, there also the same process is there.
Okay. Okay.
The same
Okay,
process there also, you will get first examination report. Yeah.
Yes, sir.
And you have to respond it, and you have to pay. And one more thing regarding the patents is you have to pay the renewal fee. You have to pay the renewal fee once it is granted. It's not many times. I'm not sure how many of you know about this one. So the more number of countries you are filing, so the more number of prosecutions will be the first step, because more number of objections will be getting, and you need to hire an attorney. Especially in foreign countries, it is very expensive. And even if it is granted, you need to pay the renewal fee.
Renewal fee.
What happens if I do not pay the renewal fee? The patent application will be lapsed. Then what is the use? There is no use.
Yeah.
And meanwhile, how much of pressure you are undergoing to get relevant information from the patent offices, submitting the documents, maintaining those documents, yeah, and paying the PCT fee, paying the national phase entry fee. At the end, you are not commercializing. Right.
Yes.
So the main intention of filing the patent application is that there should be some business interest, or at least there should be some takers. If your invention is good, and let's say I told you, right, one invention where without touching itself, you are able to open the a phone or something like that, and you are able to operate without also words, only just from gestures kind of thing. It is very good. Maybe everyone wants this kind of technology. Apple, Samsung, Nokia, everyone wants. Then that time they will contact you looking at your PCT application, sir. We are very much interested. That is the purpose of filing PCT and filing the patent application outside. So as a researchers, so there should be takers for your patents. If no one is coming to talk to you at least, then you have to understand, yes, what exactly, because it doesn't have commercial elements in it.
Okay, sir. Thank you.
So that means even if they launch a product based upon your ideas, that means no one is going to take it.
Okay, good.
So this patent is an asset. So do not convert it into a liability, right?
Okay.
So because our assets should give you returns. So once the patent is granted, you should get some kind of money from that patent in terms of royalty, in terms of sale, in terms of license or something else.
Okay, sir. Okay.
That can only happen if your invention is very good quality invention.
Okay, sir.
And someone was asking about the book.
Yes,
so
book, sir.
This is the Bayer Act book, which will be difficult for you to understand, but at least for the forms, fee and other things, you can easily understand. I already mentioned about this book in the chat box. Someone was again asking. So thing is about the forms and fees. So and the timelines are very important. So as in the first session, I was there for some time. Ram Jawar sir said that most of the researchers are filing for just publication itself. But the patent system is not just for publication. The main purpose of this patent system is to upgrade the society, to upgrade the standard of living of the society. So how can we upgrade? So let's say it is giving some limited period rights to the applicant. So dear Honorable, please post on screen. Yeah. Like what is happening is this patent. So it's once it is granted, the maximum period is 20 years. If he doesn't pay the renewal fee, it will be lapsed, right? So then what happens? Anyone can manufacture that product, and maybe he is getting a very good standard product. So that means he can discontinue. Let's say how we are evolving from filament bulb to tube light now to LEDs, right? So that means once the maximum period is 20 years, after which anyone can manufacture. So I'm not sure how many patents were there related to LED lights. I think that period is over. Now any common manufacturer, he can buy a machine and he can manufacture if there are no patents on it. So this is how we are evolving. Let's say the phones as well, like earlier big phones were there, like big headsets were there. Now we have very ultra minute things with very good processing capacities and other things. So this way we are improving, and also the home securities and whatever we are using in the kitchen, bedroom, lights, fans, everything. So that means the main ultimate aim of the patent system is to increase the standard of living. So this we have to keep it in mind.
Okay, sir. Thank you.
And-
Thank you
and
very
it
much.
is
It was,
commercial tool. Yeah. Thank you very much, ma'am.
it was very informative, sir. Okay,
Thank
sir.
you.
I'll just share the PPT, whatever you have shared me, I'll just share in the GCS. They'll make use of it. And I'll share
Yes,
your contacts also, sir, so they can make
Yes.
use of it. Okay.
Yes,
So
yes.
a few minutes, 1 minute. Participants, kindly switch on your camera so I can take a snap. So you just unshare your things, sir. PPT.
Just.
Participant, please switch on your cameras. Okay, so if you are facing difficulty, no problem.
Yeah,
ma'am.
no. Yeah.
Yeah, others,
come,
if you are, yeah, it's. Gallery.
Did you take, ma'am, the snap?
Yeah, I'm taking, sir. I'm taking, sir. Okay. Last பேஸ் கொடுங்க வேர்ட் ஓபன் பண்ணுங்க ஒண்ணுக்குன்னு வந்திருக்கு போட்டோட எடுத்து வந்துரும். Okay, sir. Thank you, sir. Thank you very much.
Yeah, thank you,
Okay,
ma'am.
sir. Thank you, sir.
Yeah. So
I'll post
one other
the.
suggestion is like here to get a publication. So it is like it is a publication is like it is not examined. Like a student writes whatever you want. It is like it will be published, but only during the examination you will come to know the what are the lacuna in it, whether it is patentable or not. Anything relating to some matter, you can get publication. So because patent publication is very easy step, by filing form 9, you can get it published, provided that you meet all the formal requirements. But in order to get a grant, it is very, very difficult. So with this, I end my session, and I thank all the participants and Pratyusha Engineering College for giving me this opportunity. Yeah, thank you.
Thank you, sir. Thank you very much, sir. Thank you very much.
Thank you.
Participants, I have posted the feedback link in the chat box. You kindly fill it up. Thank you, sir. Thank you, Vijay, sir.
Thank you, ma'am.
Thank you, sir. So just fill the feedback link so it will be easy for us to mark the attendance. The recordings, everything I'll post in the GCR. Thank you, ma'am. Thank you, ma'am. Thank you, sir. Thank you, sir. Kushpe Pankaj. Kushpe Pankaj, or is faculty ID he needs. Kanamama. Feedback link will be closed by 6 p.m. Okay. Yeah, I'm posting again, sir. I'm posting it again. I'm posting it again. The PDF. No. Sir, our Gokul Anand, sir, your faculty ID. So the PDF is again shared in the Atal group, sir. Excel sheet is again shared in the group, sir. You just view it, sir. Yeah, after finishing your feedback, you can leave the meeting. No problem. The FDP ID, faculty ID, this thing has been shared in the WhatsApp as well as in the Google Classroom. Issues are need to be done again. No need. Sir, once you fill the feedback form, that's enough, sir. No need to fill it again. Thank you. Yes, sir, you can leave, sir. Thank you. Once again, here also we have shared the Excel sheet for your reference in WhatsApp as well as in Google Classroom. Now in the Zoom link also we have shared that Excel sheet. Please go through that. That is a finalized list. Thank you, ma'am. Kindly send the feedback form again. The feedback link will be closed by 6 p.m. So try to complete the feedback responses now itself. Again, feedback link. Okay. As soon as you complete it, you can leave the room, sir. Yes, ma'am, we'll check it off, check it off. You just put the ID. In case any discrepancy means we'll put in the WhatsApp group. Let us know you. Ask them to post it in the WhatsApp group. We'll post it in the WhatsApp group. If your name is not available. Yeah, if the name is not available, in case you have logged in with any other name other than the registered name, we'll just find it out from the WhatsApp group. No problem. No issues, sir. So you can just fill the feedback and leave it. Thank you. Thank you. So tomorrow, please be on time by 9 o'clock so that only we can wind off before thing. We have to stick on with the timings. So it will be easy for us to go with the thing. So we can acquire more things because of time. We should not leave any information from the guest. Thank you, ma'am. Thank you. Thank you, Pankaj sir. Pushpe Pankaj. Thank you. Yes, I'll share all the PPTs and the recordings with the GCR. Yeah, I'll surely share. I think it will be available in the morning itself, so you don't worry. I'll get it from the speakers and I'll just share it. Yeah, only one feedback form. You have to submit. It's for the entire day. Jado sir, it is you have only one feedback form you are going to submit, and the feedback is for the entire day. Thank you, sir. Thank you. Or feedback form. Feedback link has been shared. You can take it out. எப்ப நான் Thank you, Rakesh sir. Thank you. The Excel sheet, sir. I'll again share the Excel sheet here. You just see it out, sir. So I have shared the Excel sheet again. You can verify with the ID, sir. Shopekar, sir. I have again shared the feedback as well as the Excel sheet. You can just verify it and fill it out. Thank you, Rakesh sir. Hmm? Thank you, Consular. Any man on the foot. We are ending the session now. I'll just put the feedback link again. Thank you all. We'll meet tomorrow.